Court is calling 2019 CR 6497A, State of Texas versus Mark Anthony Rodriguez. Can I have parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defense.
Joseph Stateson.
And are you Mr. Rodriguez?
Yes, ma'am.
Showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand it? And did you sign it?
I did review, understand, and sign.
Showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Okay. Going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
The air is thick with formality as the case is called. Every word spoken feels like the turning of a key in a locked door. The judge confirms each document, each signature, each acknowledgement from the accused. Mark Anthony Rodriguez answers in steady tones, but beneath it all, an unspoken tension lingers. This is the opening step into a process that could change his life forever.
Did you understand you're charged with the offense of aggravated assault with a deadly weapon? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find, I'm sorry, just 1 second.
A chilling reality is laid bare. The charge, aggravated assault with a deadly weapon, carries a weight that could mean decades behind bars. The judge lays out the rights, the risks, the consequences. The courtroom is silent, every ear tuned to each measured phrase. And then comes the question, does he understand? His answer is simple, but in that single word, a future hangs in the balance.
See, this is what happens when you multitask. I'm reading the police report plus giving him instructions. Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 20 years in prison? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Absolutely.
Are you a U.S. citizen?
Yes.
Who's the no contact order against?
Oh, sorry. I think I added that.
No problem. The court will find that defendant has knowingly and voluntarily waived his right to jury trial.
Distraction flickers for a moment, but the gravity of the moment pulls the room back into focus. Deferred adjudication, an opportunity for redemption, but also a sword hanging by a thread. The judge seeks assurance. Is the defendant competent, aware, and willing? The defense answers with certainty. Rodriguez confirms no threats, no promises, no fear. And with that, another right is signed away.
Did you review the plea bargain page with your attorney? Did you understand it? According to plea, punishment is to be assessed at 8 years in the prison. There are no, the state is silent on your application. There's to be restitution, if any, to Jose Montoya. Did you understand that to be the plea? Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
All right. And the court, if the court finds there was a deadly weapon, then the court will find there's an affirmative finding of deadly weapon. Do you understand that as well?
Yes.
Okay. Showing you the waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
8 years in prison, the figure, is read aloud without pause. The plea deal is clear. The consequences harsher still if the court finds a deadly weapon was involved. The judge explains the waiver of appeal, the finality of the decision. One by one, Rodriguez acknowledges his understanding, each yes, echoing like a slow drumbeat in the quiet room.
I had filed some motions. Because we worked the deal out, just to for the record, I think he had 13 prior settings with Raymond Martinez, who did not file motions.
Okay.
I expedited motions being filed, but my client had accepted an offer. So I don't believe the motions had been presented for a hearing.
All right. Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence
State offer states exhibit 1 in all attachments.
No objection, Your Honor.
showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand it? Did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
The defense speaks, clarifying motions and prior settings, but all roads lead back to the pivotal moment, the plea. Guilty, not guilty, or no contest. The state submits its evidence, the documents are reviewed, signed, and acknowledged. Again, the defendant affirms he understands the rights he is surrendering, the right to remain silent, the right to confront witnesses, rights that, once gone, cannot be reclaimed.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments or review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you apply for deferred adjudication. This will come back on August 12th. We'll do a PSI and TAP evaluation. At that time, the court will make its decision on your application based upon any evidence that's presented and also the PSI report. Yes.
Evidence is entered without objection. The court reviews and finds enough to justify guilt, but holds that final verdict in suspense. Deferred adjudication offers a sliver of hope, a waiting game until October. A PSI report will soon paint the fuller picture, and it is that portrait the judge will weigh before deciding if mercy has a place here.
I'm sorry, October 12th. I'm just seeing if everybody's listening to what I'm saying. So we'll bring you back on August 12th, okay? I keep saying August 12th. Why do I keep saying that? It's been a long day.
Ma'am.
October 12th. That's when we'll bring you back.
October
And
12th.
Justice Stateson's so nice. He was trying to interrupt me without interrupting me. Because no matter what you say to Joseph, his level stays here. He's like,
I don't raise my voice.
it's like that day has passed, so we're going back in time. All right, we'll see you then.
Thank you.
Thank you.
Have a seat, first row. Actually, somebody's.
The date is corrected with a weary laugh. October 12th, not August. Even in this heavy space, a flicker of humanity surfaces. But make no mistake, the path ahead is far from lighthearted. That date will not be just another day. It will be the day the court returns its verdict on Mark Anthony Rodriguez's future. Until then, the clock ticks and the tension builds.